Beneficiary deeds or transfer on death deeds. We see this all the time as estate planning and probate attorneys, where someone really doesn't want to do a trust for whatever their personal reasons are. Someone told them about a beneficiary deed or transfer on death deed, and they said, oh, it's free at the county, just go down and fill it out. It's just as good as a trust. Now, unfortunately, that's not true. There's a ton of misconceptions out there. A lot of times you'll hear a beneficiary deed referred to as a poor man's trust, and it couldn't be further from the truth. It's really apples and oranges here. But let's talk about what a beneficiary deed can do compared to what a trust can do, and what may be right for you based on your ultimate goals. Now, their similarities are when everything is done properly and everything goes exactly as planned, both a trust and a beneficiary deed can keep family out of probate court, pass on the property to the beneficiaries outside of the court system with a stepped up basis for capital gains. So that's a good way to inherit. Okay. The problem is when things don't go exactly as planned. A trust is going to be a much more comprehensive plan. A beneficiary deed is going to be more of what we refer to as like a hopes and prayers plan. We hope and pray that everything goes exactly as we expect to avoid any issues down the road. When we talk about beneficiary deed, what we're talking about is a transfer on death deed, beneficiary deed, or some states you'll hear it referred to as a Ladybird Deed, all synonyms here. But what it is the property's title stays in your personal name while you're alive. And when you pass away, there's a designation for who's going to inherit the property. And in the case of a beneficiary deed, it's recorded at the county. And it has to be done according to law. So it has to be signed, witnessed, notarized, and recorded within 60 days. And you have to have the right kind of beneficiaries listed for it to be proper. But if you get it done according to law, it will avoid probate court for your listed beneficiaries. The core deficiencies in a beneficiary deed over a trust is really when things don't go exactly as planned. And what we mean by that is when a listed beneficiary passes away before you. Sounds crazy. We see it all the time. When a listed beneficiary is receiving government benefits, when a listed beneficiary is going through a divorce, or they have creditors, or going through bankruptcy, when a listed beneficiary has substance abuse problems or an addiction problem, and receiving that inheritance outright is not good for them, when a listed beneficiary is a minor, when your listed beneficiaries have a difference of opinion for what should happen to the property after inheritance. These are all things where you would not want to have a beneficiary designation deed. You would want to have a trust in place to take care of these contingencies. When we talk about a beneficiary who's listed on a deed passing away before you, in that kind of scenario, they're cut out. Their bloodline is cut out. So there are no grandchildren that are going to take in their place. It's just going to go to the remaining listed beneficiaries. And if you only have one beneficiary listed and they pass away before you, now we're into probate court anyway. So again, it's hopes and prayers that everyone listed outlives you and that they don't have any of these problems at the time of inheritance. So they're not on government benefits because there's no way to protect it, through a beneficiary deed like there is with a trust. They don't have any addiction or substance abuse problems because in a beneficiary designation deed, there's no way to protect that inheritance like there is in a trust. They don't have creditors. They're not going through bankruptcy. They're not going through a divorce because there's no way to protect that in a beneficiary deed like there is in a trust. The people who are inheriting are responsible adults who are actually going to do what it takes to transfer the property into their name and then do their own planning so that we don't end up in probate court at their passing. There's no way to protect or plan against that in a beneficiary deed like there is in a trust. And what we see a lot of is the people who inherit through beneficiary designation, they all hopefully agree with what should happen to the property, be that the property be sold and split, the property be turned into a rental and the proceeds split equally, and hopefully they put together their own agreement for how that's going to go, or one of them is going to live in it and buy out the other. Hopefully whoever's listed on that beneficiary deed all agrees, because if not, while we're not going to end up in probate court, we're going to end up in civil court with them suing each other as property owners now for what should happen with that property. Partition actions are common there, where one person, lives in the property and excludes the others, and the other wants their funds, but the person living in the house isn't going to, buy them out. Well, the other property owner is going to take them to court. force the sale of the property so that the proceeds can be split. No way to protect against that in a beneficiary deed. When we don't have beneficiaries who agree, meanwhile, in a trust, we can avoid all of that infighting, say what's going to happen with the property, and preclude not just probate court, but also preclude the post-inheritance fights that can happen when you don't have structure around the inheritance. Now, does that mean beneficiary designations are never right for anyone? No, of course not. We rarely will do them when, it makes sense. Usually it's going to be a one beneficiary scenario and someone who's about to pass away. It's kind of that deathbed type plan, if the stars align. Now, along that line of thinking, though, beneficiary deeds are a lot easier to challenge if we have like multiple kids, but only one is receiving the property. And that's done in like a deathbed type situation or end of life planning, and the other kids are cut out, especially if it was just scratched out at the county on their own and there was no attorney involved. It's a lot easier, in my opinion, to go and challenge that, be it undue influence of that one inheriting child, as opposed to, a trust that was attorney prepared and an attorney was involved and they can attest to the wishes of the decedent. So you have to be careful with even the simple beneficiary designations when it seems like it's a good idea. You have to be careful around, is this going to be easier to challenge, and does this appear to be undue influence in the execution of the document? So it can work in some situations, but in my opinion, it is very rare for a beneficiary deed to be the best option for you. Especially nowadays, we're getting together a simple software-based trust like our ready-made plans, where those more comprehensive plans than a beneficiary deed can be done for under $1,000, including moving the property into the trust. In my opinion, when you weigh the cost of the two, a software-based trust is going to way outperform a beneficiary deed. And of course, a more comprehensive attorney-drafted trust, yes, that's going to be in the $3,000 to $5,000 range, is probably going to be the best for most people. But it's not like we're bridging the gap of $3,000 to $5,000 comprehensive plan versus a beneficiary deed in today's marketplace. We're just not. Software-based trusts have a void to fill there to provide much more protection than a simple beneficiary deed, without getting into the super comprehensive nature of an attorney prepared trust. So because there's more options in the marketplace today, I would say a software-based trust like our ready-made plans are going to way outperform a beneficiary deed for 99% of the situations out there. Now, if you'd like to learn more about what all of your options are in dealing with your property, whether it's no plan, a will-based plan, beneficiary designations, a simple trust, comprehensive trust, advanced planning, what that spectrum is, what the costs are involved in those spectrums, and really what all is covered in each of those types of plans, we've put together a free seminar that's going to cover all of that knowledge in one place. Click the link in the description of this video, jump over to that seminar so that you can learn what may be best for your family, and I'll see you there.